Sierra Jones, case number 23056831101. Appearances for the record, please.
Morning, Your Honor. My name is James Kehoe, and my P number is 82812 on behalf of the people.
Good morning, Your Honor. May it please the court, Bertrand Johnson appearing on behalf of Sierra Jones, P46646.
Ms. Jones, unmute yourself and tell us your name.
Hi, my name is Sierra Jones.
Okay, so before we begin, I have some disclosures to make. First and foremost, I was pretty good friends with Ms. Jones' father, who was a well-known attorney that practiced in this building as well as all throughout the Third Circuit Court as well as the state of Michigan. In fact, I knew her father so well that I actually spoke at his funeral, and I met Ms. Jones when she was about 3 or 4 years old. I have not seen her since. Last time I saw her, I think she was about 4 years old. So I don't have any relationship with Ms. Jones or her brother or her mother. But I am familiar with Ms. Jones as well as her brother, her dad, and I don't think I've ever met the mother. But I want to make that disclosure just in case anyone has any objection to me staying on this case. Let me say for the record that I think it would not be a problem for me going forward presiding over this case. I think that I can be impartial. In fact, I know I can. Does anyone have any objection to me staying on this case?
Judge, at this time as counsel, I have no objection. As far as a conflict, we first start whether there's a potential for conflict, and I don't see any potential for conflict at this time, and I clearly do not see a conflict of nothing's been brought to my attention that would indicate that there is an actual conflict at this time. So therefore, I have no issue with this court remaining on this case.
All right, Mr. Kehoe.
I have no objection, Judge.
Okay, very well. Okay, what's your pleasure, Mr. Johnson?
Your Honor, obviously I've just spoken for the first time with Ms. Jones. I also spoke with prior counsel. There were some discussions about referring her for competency prior to the exam. I've spoken with her at length. After speaking with her based on her disclosures, I thought it would be effective and competent on my part to refer her. As I indicated to her, I do believe she will come back competent, but to be effective and to be competent, I thought that as counsel, as new counsel, based on what she told me, that I should refer her. However, she appears to have some misconceptions about how this case will proceed. Hold on, ma'am. With respect to a bond hearing or something of that sort, I indicated to her there is no bond at this point on a first-degree murder. I indicated that she was not going to have a pretrial. I indicated her next hearing is a preliminary exam, and I indicated to her that forensic examination would take about 60 days, but it would also shine some light on other issues that may be helpful to her case, and that I did believe she would come back competent. At this time, she indicates she does not want to be referred. She feels it's her right to object to that, and I told her that I would let the court make that known to the court, and judge let you proceed as you see fit.
Ms. Jones, I want you to understand what the role of Mr. Johnson is, and that's to look out for your best interests. And we want to make sure that we proceed cautiously in this matter, make sure that every T is crossed and every I is dotted. So we have to start from square one. And if the attorneys are concerned that there may be some mental health issues here, we want to make sure that you understand this process. We know that you've been around the criminal courts for as long as we can talk. But we want to make sure that everything is done appropriately. And in so doing, I am going to refer you for a competency evaluation. It's not only in your best interest, there may also be some strategic reasons that Mr. Johnson may be pursuing and going forth in that fashion, okay?
So would that mean my preliminary exam is going to be pushed back, or it's going to be not on June 1st?
No, it's not going to be on June 1st. It will be pushed back.
So if I don't have because with all due respect, I don't have a mental illness. My mom petitioned me into the hospital because me and her had conflict towards each other since I was a little kid. And she never called me like mental. this happened within this year, so I never really got put in a mental hospital before until like
Well, you're not being put in a mental hospital now. You're going to be evaluated to make sure that you appreciate and understand the charges that are brought against you, that you're able to assist Mr. Johnson in his defense of you. We want to make sure that that's done before we go forward. So can I get your cooperation in that?
I mean, you can, but it's like that kind of like traumatizes me when people call me mental ill because I'm not mental ill. I don't even feel like people have to go through this and they have a right to say they don't have to go through this.
Miss, I've never called you that, and I'm not going to refer to you that. And I also indicated to you that I believe you will come back competent. I told you that 9 times out of 10, that I'm quite sure. But I said to be effective and to be competent, I think that we should refer you.
Right, but
I will never refer to you as mentally ill.
If I had a different lawyer, like I didn't feel like I had to do that.
I don't think any counsel would disagree with Mr. Johnson at this point. In my 27 years of practicing and knowing your dad very well, your dad knowing me very well, I think your dad, nobody's calling you mentally ill. We just want to make sure that you're able to assist Mr. Johnson in your defense. And we want to make sure that we set forth a paper trail in that regard.
I don't want Mr. Johnson as my lawyer either.
Well, you don't get to
If I
decide
get a lawyer, do I still have to go through the process?
Mr. Johnson, listen to me. You don't get to decide who your appointed counsel is. Mr. Johnson is a very good attorney. In fact, Mr. Johnson used to be my boss back in the day. Remember that, Mr. Johnson?
Oh, yeah.
I used to work for Mr. Johnson. He's been around for a long time. I hate to say that to Mr. Johnson, but he's been around for a very long time. He knows what he's doing. So he's acting in your best interest. He may not seem like it, but trust me, he is.
So if I had my other lawyer, would I still have to do 60 days?
It's actually going to be
like the competency lawyer.
Yes, because Ms. Michon also indicated that she wanted you to be referred as well. Okay. All right. So the court is going to make the referral. We'll set the review date for August 25th, 2023 at 9 o'clock. 8:30 a.m.
Yes. I would just ask the prosecutor, could he give me the discovery?
We'll be in touch, Mr. Johnson. I gotcha.
Okay, thank you. Thank you, Your Honor.
Can I get my next court date?
I will see you at the jail. I'll come over and see you, ma'am. Explain everything to you.
All right. Thank you.
Judge Kenneth?
Yes, ma'am.
Are you familiar with my next court date? My preliminary exam, since it's been pushed back?
First, before we get to the preliminary examination, we have to make a determination that you are competent to stand trial. And that competency hearing is going to be August 25th. That's the next date I'll see you.
Okay, and what happens if I'm not competent?
Then they will treat you until you are competent.
I'm sorry, you said they will tell me I'm competent?
They will treat you. They will give you treatment trying to get you competent. They have a little bit over a year to get you competent. If you're not. But it does sound like, and I have to agree with Mr. Johnson, you probably are going to be found competent. But we want to get that in writing from the experts, okay?
So if I am competent, I go to trial, and if I'm not competent, I go to trial?
If you are competent, then we go to the preliminary examination. If you're not competent, then you will continue to get treatment until we can get you competent.
And so until then, I would have to stay here to get competent?
You may be at the forensic center being treated, not necessarily being competent.
And then I won't be going to trial until then?
Until you're found competent.
Okay, I'm sorry to laugh. Okay.
Okay, thank you very much. Thank you, Mr.
Thank you,
Johnson.
Your Honor. Thank you.
Okay. I'm sorry for being difficult. I don't know. Like, I never really had a mental illness. I feel like my mom was always making fun of me for.
Okay. I don't want you to tell me anything about your relationship with your mom or the case or anything like that, especially without your attorney being present. We don't want you to say anything that's going to hurt you, okay? So have that discussion with Mr. Johnson, okay?
Okay.
All right. Let the deputy know you're all
When
set.
is my next court date? It's in 60 days?
August 25th.
Okay.
Okay?
Booker?
Yes, that is correct.
Did this case get sent to the DWI court?
Yes, it got rejected from the DWI court.
All right. Okay, here we go. This time, the court will call the case of Demetrius Stansel, cause number 649716. Would each side state their name and who they represent for the record, please?
Field partner for the state.
Nell Smith for defendant.
Good morning, Mr. Stansel. How are you doing, sir?
Good morning.
Are you the same Demetrius Stansel who's been charged in the DWI second?
No, same.
Are you a U.S. citizen, sir?
I am.
Have you had an opportunity to discuss this case with your attorney?
Not really, but
Okay.
I mean, yes. We've discussed it. Yes. I'm making my plea today, Your Honor. I'm prepared. I'm ready.
Are you sure? Because
Yeah.
I was pleading, you guys can go right back in the breakout room and discuss
I'm
this.
ready. I'm ready.
Okay. Counselor, are you sure your client is competent enough to move forward in the plea today?
I
Counselor.
think we should go back in the breakout room, Your Honor.
All right. Step back.
No, please not.
Nope. Step back. Booker, put them in a breakout room together. Okay, so we're back on the record with Demetrius Stansel. Are you guys ready to move forward?
Yes, Your Honor.
We are.
Okay, very well. All right, so I'm just going to start over again, okay? So at this time, the court will call the case of Demetrius Stansel, cause number 649716. Would each side state their name and who they represent for the record, please?
Field partner for the state.
Nell Smith for the defendant.
Good morning, Mr. Stansel. How are you doing, sir?
Good morning.
Are you the same Demetrius Stansel who's been charged with a DWI second?
I am.
Are you a U.S. citizen, sir?
I am.
Have you had an opportunity to discuss this case with your attorney?
Yes.
And counselor, are you satisfied your client is competent enough to move forward in the plea this morning?
Yes, Your Honor.
Mr. Stansel, did you get an opportunity to go over a document entitled Defendant's Waiver of Constitutional Rights and Court Admonishments?
I did.
Did you go over that document with your lawyer?
Yes.
Did you understand it?
Yes.
Did you sign that document?
I did.
Counselor, are you satisfied your client understands his waiver of constitutional rights?
Yes, Your Honor.
Mr. Stansel, are you entering into your plea voluntarily this morning?
Yes.
State, is there a plea bargain?
There is, Your Honor. We're proceeding on the DWI second, Class A. The plea bargain is for a $600 fine. Court costs 12 months. Bear County Jail probated over 12 months. DWI intervention, victim impact panel, TAP evaluation, ignition interlock for half the term, 180 days in Texas driver's license suspension, 30 days GPS, no monitoring, and 40 community service hours.
Do you have the number for one of them?
40 hours of community service?
Yes, Your Honor.
Why are we doing 30 days of GPS?
Because statutorily, well, I offered it instead of jail time, Your Honor.
Nell, what is your response to this?
My client would like to do GPS instead of jail time.
Okay. Well, Nell, I'll give you this advice because you're a very new attorney. Even if they had offered him jail time, I probably wouldn't have assessed it. I probably would have just held it in base. But that's for another day. Next time, remember that, okay? All right. This is everyone's understanding of the plea bargain agreement? Everyone?
Well, Your Honor, I would like to ask you questions off the record, or I'll come down to the courtroom if that would be okay, and we can stop this plea right now.
Well, Nell, this is the issue. I know you're very new in the public defender's office, and I respect that there are supervisors who will be training you on these issues, like of these things, of these pleas that are going forward. Like this was something that I think that your supervisor should be telling you how the pleas are done and how to move forward in pleas, what to put in pleas and what not to put in pleas. And that's not on you. That's on the public defenders. That's not on you. You're new. Now, do you guys want to stop and move forward, or do you want to continue? Do you want to continue with this, or do you guys want to stop?
I think we should stop and I should talk to my client.
Can I just speak for a second, Your Honor? Like this is my concern. Is not that she's not a nice person, not that she's not trying, but that like I can tell like that she's and it's because she's new, right? But my case has been handled by so many different people, and that's why I feel like it's not getting handled accordingly. But I'm willing to take the deal because what I'm being told is this the best deal I have to offer. So all I'm asking for you is just to be a fair and impartial judge at this matter and just help me get the best that I can get with this. Because at this point, it's been 2.5 years and 4 counselors. And I'm a single father and I have a lot going on. So I just really need to get this over with.
Sir, this case is being handled by the public defenders. If you don't like what they're doing, there is an option that you can hire your own attorney. Like this case has been going on for 2 years. That's completely what your defense is. Like, I don't have anything to do with that. The deal that is being made is being presented to me. I have no part in making the deal. That deal is being presented to me as the judge. And I can either accept or not accept the deal that's being presented to me. But what is going on, how that deal is going out, that's between your attorney and the public and the DA's office. And so this offer that's on the table right now, you can either move forward with it or your attorney says she wants to stop and reconsider some aspects of the deal. But if you want to move forward with it, we can move forward with it.
Now, how soon can you get me back in court if we balance pauses?
I don't know how soon, but I can ask for a reset.
Or can we do the sidebar and come right back just so we can discuss whatever it is you need to discuss?
Yes, is that okay, Booker?
Yes. We can recall it as soon as tomorrow.
Let's recall it for tomorrow, could we, Demetrius?
Okay. But that means we need to talk like as soon as we get out of here so we can really figure out what's going on. It's not waiting for
tomorrow, Booker. We can put Nell back in this breakup room with her client.
Okay, thank you, Judge.
Thank you all.
The record, I'll start again. At this time, the court will call the case of Demetrius Stansel, cause number 649716. Would each side state their name and who they represent for the record, please?
Caleb Portman for the state.
Nell Smith for the defense.
Good morning, Mr. Stansel. How are you doing, sir?
Good morning.
Are you the same Demetrius Stansel who's been charged in the DWI second?
I am.
Are you a U.S. citizen, sir?
I am.
Have you had an opportunity to discuss this case with your lawyer?
I have.
And counselor, are you satisfied your client is competent enough to move forward in the plea this morning?
Yes, Your Honor.
Mr. Stansel, did you get an opportunity to go over a document entitled Defendant's Waiver of Constitutional Rights and Court's Admonishments?
I did.
Did you go over that document with your lawyer?
Yes.
Did you understand it? And did you sign it?
Yes.
Counselor, are you satisfied your client understands his waiver of constitutional rights?
Yes.
Mr. Stansel, are you entering into your plea voluntarily this morning?
Yes.
State, is there a plea bargain?
There is, Your Honor. We're proceeding on the Class A DWI second.
No.
Plea offer is for a $600 fine. Court costs 12 months. Bear County Jail probated over 12 months. DWI intervention, victim impact panel, TAP evaluation, ignition interlock for half the term, 40 community service hours, 72 hours continuous Bear County Jail, and 180 days Texas driver's license suspension.
Okay. Is this everyone's understanding of the plea bargain agreement?
Yes, Your Honor.
Okay. All right. Mr. Stansel, how do you plead to this charge?
No contest.
No contest. Very well. The court accepts your plea of no contest. Fine has been voluntarily and intelligently entered into, and also punishment as follows. We're going to move forward with a $600 fine. Court calls 12 months in the Bear County Jail, probated for 12 months, a DWI intervention class, the VIP class, a TAP evaluation, ignition interlock for half the term, 40 hours of community service, 72 hours jail time, which I will hold in abeyance, 180 days driver's license suspension, also a supervisory fee at $40. Is there anything else from either side?
Nothing from the state.
No, Your Honor.
Okay. There's nothing else from either side. Sir, I have followed your plea bargain agreement. You do not have my permission to appeal this. Mr. Stansel, I'm going to put you in a breakout room with our probation officer, Mr. Kimbrough. Counselor, did you want to go into that breakout room also?
No, thank you.
Okay. Counselor, does Mr. Stansel reside in Bear County?
Yes.
Okay, very well. All right. Everyone is excused. Good luck to you, Mr. Stansel. Just look wait for that join button pop up. All right, everyone is excused. Thank you, Counselor, for coming on to hear this matter.
Next, we have Michael Podway. So you've been charged with Allen County misdemeanor on an underlying criminal trespass from McLennan County. I guess it's Waco. Is it in Waco?
Yes.
All right. That bond has been set at $10,000 cash assurity. I have removed the cash assurity condition and reduced the bond from $10,000 to $3,000 to allow you to post bond out of Travis County and not have to wait the 10 days in jail for McLennan County to pick you up. Will that help you?
No.
Nope.
I don't have any money right now. Is there any way to get a PR bond?
We don't do PR bonds on out of county holds, sir. Only for Travis County holds. However, if any alternative, I will appoint you counsel that can help you obtain personal bond. Would you like me to appoint you an attorney this morning to help you?
To get a personal bond?
Yeah.
What does that mean? Sorry.
To bond you out. This is not a hotel, so we don't want you to necessarily stay here a very long time. Do you want a court-appointed counsel to help you?
How are they going to help? I don't have any money.
They work for free, sir. The state
So they'll get me like released because of that?
potentially. Would you like their help?
Yeah, I appreciate that.
Okay.
No, sorry, it's my first time in trouble ever. You know what I'm saying? This whole thing
What do you mean the first time in trouble ever? Where's this case stem from? I mean, why are you here and you got this case in Waco?
Yeah, I don't even remember what happened. I have no idea. And this is the first time I've ever been in trouble too.
Oh my goodness. Well, I'm sorry to hear that, but that's a very small red county. So they will leave you here for 10 days unless we give you some help.
Okay, thanks.
You have any other questions for me, sir?
No.
All right, take care of yourself.
Yep.
All right, Mr. Green. Pleasure meeting you. I'm sorry. Pleasure seeing you again, but not under these circumstances. Why you back in jail, sir? You just shaking your head. You too old to be going to jail at this point in your life, because we the same age.
Yes, ma'am.
What is going on with you?
It's time to go home, man. Time to go home.
Now you know Judge Brown. You know he gonna give you a big old talking to, man to man. Is he gonna revoke you? Have y'all talked about this already?
No, I have not. I haven't seen him.
You think he gonna revoke you?
I don't know. I got charges pending. So I don't know. I hope I can just get out of them. I don't know what's going on.
Poor child. I was like, Donna Green is not back in jail.
A long time.
You just had your brother maybe about a month ago.
Yeah.
I don't even think it was a month ago now.
Yeah, about a month ago.
Yeah, it wasn't that long ago.
No, it was not.
All right, okay. Let me stop giving you the ride, giving you a hard time. Like,
It's okay,
I'm going back
okay.
to jail.
Yeah.
Old to be going to jail, sir. We too old.
You're right. You're right.
All right.
You're right on that one.
Let me start with the motion to revoke your probation from Judge Brown, the 147th District Court. Of course, you know it is a no bond, so you will have to have a hearing in front of Judge Brown within the next 5 to 7 days so he can determine if he's going to set a bond. All right. In addition to that, you have a new second-degree felony in possession of controlled substance. The range of punishment on that type of offense in the state of Texas is a minimum of 2 years to a maximum of 20 years in the Texas Department of Correction and a $10,000 fine. That bond has been set at $10,000 plus a drug court screen. In addition to that, sir, you have 3 third-degree felonies. The range of punishment on those types of offenses in the state of Texas is a minimum of 2 years to a maximum of 10 years in the Texas Department of Correction and a $10,000 fine. The first third-degree felony has been styled as an evading arrest. That bond has been set at $10,000. The second third-degree felony has been styled as a tampering or fabrication of physical evidence. That bond was also set at $10,000. And finally, sir, the third and final third-degree felony has been styled as an assault family violence. That bond was also set at $10,000. Do you have any questions, sir, regarding your charges or bond amounts?
No, ma'am.
Are you requesting that I appoint you an attorney this morning to help you with this case?
No, Henry Carter is my lawyer. He was already had paid him because I knew about the probation and the assault charge.
So who is it? Who's your lawyer?
Henry Carter.
Oh, Casey. All right.
Yeah. Mm-hmm.
So he's working on these bonds already?
I guess, he's, should I say, I have a no bond, so I guess he can take care of everything once he try to get a bond to the probation.
Right.
Yes,
Once you approach Judge Brown and
and
find out.
contacted. He's already paid. Yes, ma'am.
Okay. Well, that's why I'm asking you what Judge Brown is going to do, whether you feel like he's going to revoke you or not.
I don't know. I hope not. With these cases,
Well, the drug cases, I mean, right? That's a non-issue. It's really the assault. So my question to you is the big...
my kid's mom, she already went down to the pretrial service field, did the non-prosecution affidavit.
She did?
Yeah, they supposed to be dropping the charge. They supposed to be gone. We did everything. She talked to him, and I don't understand why the charge is still there. That's what I'm.
Donna Green, have you seen your rap sheet, Donna Green?
Yes.
That's why it's still there. You know why it's still there. Stop.
Well, I'm saying, but if they told her that, she's supposed to be doing all this, why is it still there? They said they were going to dismiss it. So they dismiss it in court or what?
Yeah, you just have, Kennedy knows what to do. So he gets that one take care of, the rest of them will get dismissed. So then you just got to deal with Judge Brown on your probation. You know how this works.
Yeah, I'm all right.
So, just go and apologize to him. Tell him, you're doing better, you're working, you da-da-da-da-da. You know how to do it. And hopefully he'll reinstate you and put you back out there on probation.
Yes, ma'am.
All right, good to see you again, but not under these
Good to see you
circumstances.
too. Congratulations to the judge position.
Thank you. Take care of yourself. Tell your brother I say hey. All right. Next we have Jake Kill. Come on forward, sir, and take the empty chair. So you've been charged with felony burglary of a habitation. The range of punishment on that type of offense in the state of Texas is a minimum of 5 years to a maximum of 99 years or life in prison and a $10,000 fine. That one has been set at $40,000 plus a stay away from the alleged victim plus a scram device. Do you have any questions, Mr. Kill, regarding your charge or fundamental?
No, ma'am.
Are you requesting that I appoint you an attorney this morning to help you with this case?
No, ma'am.
No? Who did you hire somebody? Which is good.
Yeah, I already have one, and I'm going to talk to him about it when I get a chance.
Okay, who is that?
Dan Hamry.
Well, I know Mr. Hamry. He's a long-time prosecutor here.
Yeah.
All right. And also a very good attorney. Now listen, let me caution you because they were requesting an EPO, an emergency protection order, but I know that you actually live in this apartment complex, right?
Yeah, correct.
So I don't want to render you homeless, right? So I'm not
Yes,
going to
ma'am.
enter the emergency protection order, but I am going to caution you to stay away from her so she can continue to call the police and get you arrested.
Yeah, absolutely. I understand.
Okay?
Yes, ma'am. So
Yeah,
the 40, is that going to have to be 4,000 typically?
Correct. The going rate to get out of jail in Travis County is 5 to 10% of the bond amount. So that's $2,000 to $4,000 to any attorney or bondsman of your choice. They all take different amounts. You just have to negotiate the fee that's appropriate for you.
And I have one more question. So the
Yes, sir.
scrap device has to go on before I leave. Do they typically come the same day? Like if I were to post it, say around, I'm probably not going to be able to talk to him until like 10 o'clock. You know what I mean?
The earlier the better. Then you run the risk of being able to get them over to you. So the earlier you can get something going, like if you have a family member out there that can help, that'll kind of speed it along.
Okay. All right. Thank you.
No, you're welcome. And I just want to say this too. You're not as young as the other gentleman, but you are pretty young. This drinking, Mr. Kill, is getting you in a lot of trouble, sir. Now, you are innocent until proven guilty. Not suggesting you're guilty of anything, but the drinking is an issue.
Yeah, I know. It's terrible.
Okay.
Did you by chance? I didn't really understand. I guess it's not really. I didn't really understand how I got that charge, to be honest, and not just like.
I think because you were drunk.
Saying
And you don't remember what happened, but you scared the alleged victim to death. You just scared her to death.
Yeah.
But again, you are innocent until proven guilty. You're going to be going to court for the next couple years on this. Mr. Hamry's, of course, familiar with the process. Let him do his job. I'm sure he will handle it very well for you. Okay.
Thank you.
You're very welcome, sir. Take care of yourself.
You
Work
too.
on the drinking, though. Work on the drinking.
Yeah. I will.